This was a tragic case where reckless driving and substance abuse led to a life lost. The defendant's history could not be ignored. Today, the court weighs responsibility, family impact, and justice.
Good morning. Are you Christopher James?
Yes, ma'am.
And Mr. James was previously in court, entered a plea of guilty to the first-degree felony offense of intoxication manslaughter with a vehicle. I've received the pre-sentence report and also a supplemental memorandum from probation that includes several letters from the victim's family members. Has everyone had an opportunity to review all of that?
Yes, we have, Your Honor.
Are there any additions or corrections to that pre-sentence report?
No, Your Honor, I just want to make the court aware, Mrs. Addison, the deceased's wife, would have been here today to do victim impact. She had to go to the hospital yesterday. She's able to tune in, I believe, and watch us. The rest of Mr. Addison's family is here, and his mother is going to want to do victim impact at the end of sentencing.
Okay, thank you, Mr. Nichols. Any witnesses with regard to sentencing?
No additional witnesses, Your Honor.
All right, Mr. Lewis, you may make argument.
Okay. Judge, of course, this was a very tragic situation that has affected a lot of people. Of course, the decedent, Mr. Addison, his family, as well as Mr. James and his family. It was a situation where, this was a combination of a long substance abuse history of Mr. James. The assessment that's provided in the PSI here says that there was about a 20-year relationship between Mr. James and different substances over a period of time. The one thing I can say is that once Mr. James went through this situation with this accident, he has been doing everything he can to try to better himself. He has got his high school diploma. He's was baptized and has definitely changed his ways in going to his faith and continuing in that regard. He's also got some different certifications that he was able to receive dealing with OSHA. I think it was Men's University, things of that nature to try to better himself, Judge. Now, it's no secret he does have a long criminal history that even included dealing with PCP, which is the same substance that was involved in this accident, and as well as other serious offenses. I do want to address something as far as I know there's some situations here dealing with the jail instances, and I know how the court proceeds or looks at the situation here dealing with those. Mr. James, if you look at these situations, majority of them did come from situations involving him and other inmates, as far as any type of fight or anything like that, which unfortunately some things he can't avoid. But as far as anything dealing with being disrespectful or anything towards jail employees or things of that nature, there's one situation I think that they were talking about that it wasn't an actual write-up, but it was notated. He has been a trustee over there for a period of time at the jail as well. Now, I do want to point out that, of course, some of those situations that Mr. James was able to do to better himself, of course, could definitely increase his earning potential as far as what he has as far as his job situation. He does have significant family support. His brother is here today in the courtroom, who in any way is there to try to help him, including helping secure employment. My understanding is the plan, once he is able to be released, is for him to be moved to Houston, Harris County area, to be close to his brother, to help him with everything over there. Now, PSI did have a recommendation for his different vehicles that support that's available to him through the probation department. What I will say is that everything that has been recommended, he definitely needs and will be better for him. We are not, and ourselves are not asking for a specific number or anything like that. We just want him to be able to, of course, make amends for this situation as much as possible, which could include some of the restitution there. I think the amount is over $100,000 for his restitution there to the family. Now, like I said, he has made a plan to try to better himself. He has a family that supports him. He is doing everything he can. He understands that this was a tragic accident, but one he was definitely responsible for. And what we're asking for is as much leniency as possible from the court, for him to be able to move forward with the situation, be able to make amends as much as possible. And I think he did provide a letter to the court as well to kind of speak to that as far as an apology letter that was to the family, his family, the family of the victim, as well as to the court, Judge.
And I've received that.
And so that's what we're asking for today, Judge, is for everything to be considered. We understand this is, you can't bring that person back. He can't just go back to make amends with Mr. Addison, but he wants to try to make as much of amends as he can to society and do better going forward, Judge.
Thank you, Mr. Lewis. Mr. Nichols.
Your Honor, I think any consideration to Mr. James's due was given when he got a 50-year cap. I have no hesitation asking the court to exercise the full 50 years. This case is one of the worst intoxication manslaughters. It's on video where he plows into Mr. Addison, who's at a stoplight on a motorcycle, and while trying to get away, runs over him and the motorcycle again. It's horrific, Your Honor. What is also just inconceivable to me is that a man who's on parole for several possessions of finalization, PCP, finds himself behind the wheel on PCP again. And this time it ends in the death of somebody. His criminal history is extensive. It starts with minor drug offenses, then a conviction for aggravated robbery, and then I believe it's 5 drug convictions all at the same time in 2020, for which he was quickly paroled out and on parole when this happened. The fact that he gets to make plans in his mind for a day he's set free, I find rather offensive, and I think the Addison family finds offensive. They lost a son, a brother, a husband. There's nothing we can do in this courtroom makes that better. And sometimes the justice system is a poor substitute for what people lost. I think the best we can do at this point is this man spend 50 years in prison where he cannot hurt anybody else due to his own selfish decisions and continued use of substances. It's in the pre-sentence report. He minimizes his own addiction, his own dependency. He even claimed he did not know how he could have gotten PCP in his system the day this happened, that maybe he touched a bottle and it transferred through his skin. And I find that reprehensible, Your Honor. And that's why I'm asking the court for that full 50 years.
All right, thank you. So, Mr. James, a couple of things that Mr. Nichols didn't say that I think are also extremely important is this isn't your first driving while intoxicated. This is your third. And so you didn't learn in 2006. You didn't learn in 2017. 2017, you got your second DWI. You were given probation. It was revoked. I appreciate that you entered a plea of guilty because for myself and for the family, I'm glad we didn't have to see what it looks like this would look like on a video.
The defense highlighted steps taken to rehabilitate, from education to faith and family support. But the prosecutor pointed to a long criminal history and repeated substance offenses. The court must balance remorse, mitigation, and public safety.
Because it is just horrible. And the fact that you are truly saying that you think you touched something and got PCP when you have had PCP cases over and over and over again, and you're on parole for possession of a controlled substance and you kill someone. It's a nightmare. Sure, go ahead.
Can I say something? You know, that night that accident happened, I've been clean the entire time I was on parole. Okay, I stopped off at a friend's house and gave him some advice about what he was doing. And during that time, I did contact a bottle of his. You know, I was not high at that time at all.
It was in your
I would
system.
take- Yes, ma'am. If you know how I fight.
At this time, based on your history, based on the nature of this offense, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter. I'm going to sentence you to a term of 50 years in the institutional division of the Texas Department of Correction. There will be a deadly weapon finding based on the indictment alleges a deadly weapon. You will receive credit on this sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement and I followed it, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. There's really so many other things I could say about how horrible this is, and rarely am I out of words, but I really don't have the words to say what a tragic circumstances based on your behavior this led to. Y'all can have a seat at council table for the victim impact statement, and we'll go off the record. Do you want me to leave it on for the other family member to
I
hear?
think that would,
If Stratton Jr.? And so Mr. Stratton, in cause number 19-33601, charged with capital murder, and this, we're back again on this. Mr. Radford has been appointed to represent Mr. Stratton. And Mr. Radford, have you had an opportunity to get started on discovery?
Judge, I have gotten a transcript. I've got a huge trial docket coming up in the next 2 months, and I haven't had a chance to read it. I have also visited with Mr. Stratton. I've gotten discovery from Ms. I've gotten the paper discovery
Okay,
from Ms. Malfino, and we have visited preliminary, excuse me,
easy for you to say.
initially, about a possible resolution to this case that doesn't involve trial, but we're going to have to do some further negotiations, and I think she has to visit with some family members.
Sure. And I know there's probably also some audio, video and things that you need to get.
Yeah, I haven't gotten any.
So obviously, Mr. Stratton is going to take Mr. Radford just a little bit of time to get up to speed on this. And so what I'll do
We've
based
been
on,
working to recreate the file, Judge. It just was in several different places, including the district clerk's possession. I have prepared a written notice asking them for the trial evidence to be returned to the possession of the state.
Okay.
I also have the transcript thing.
I've gotten the
To
transcript.
Ms. Tanner, and we will begin going through that and recreating the file. If there's anything additional Mr. Radford needs, he knows I have an open door.
Judge, could I get 60 days on this?
well, I was thinking for sure 60.
Yeah.
I mean, I think realistically, obviously, it's going to take you some time to get up to speed, get the file recreated. We don't want to put it off too long. We need to get it taken care of, but I know everybody needs some time. So we're in, we're in September. We're not in August anymore.
I've got 4 huge trials.
Well, so why don't we do this? Why don't we come back first part of December, which is about 70 days, 75
Right.
days-ish. Let's find out where we are. And at that point, if you guys could at least have an idea if it's going to trial, then we can get a special date next year so that everybody's ready and available, and we'll get it set at that point if we need to for trial.
Yes, ma'am.
Okay? All right. Thank you. You can go back with the bailiff. Good morning, sir. You're Brandon Dodd?
Yes, ma'am.
And Mr. Dodd, in cause number 24, DCCR 2418 is charged with murder. What is the announcement?
Your Honor, he previously rejected 35 years. We asked him to stay on the trial docket. We have everything.
Okay. So there's no other negotiations. And Mr. Dodd, we've already gone through what you're charged with, what the possible consequences are if you go to trial. And you visited now with Mr. Burbank and you want to go forward with your trial. Is that correct?
Yes, ma'am.
Okay, we'll get it set on the next available trial docket and we'll see you then.
There is a co-defendant if you want to keep them together.
I don't know that we're worried about keeping them together.
Oh, okay. I
Yeah.
just didn't know if there was a-
Okay, thank you. All right, you can go back with the bailiff. And then you've got Traylon Hill. Not for me, for somebody else, unfortunately.
Good morning, Your Honor.
Good morning. How are you?
Doing great.
This could, this is just to go to whatever, do you have the orders on those Burbank's motions? Good morning, you're Traylon Hill.
Yes, ma'am.
And Mr. Hill, in cause numbers 24 DCCR 1500, 1614, 1615, and 25 DCCR 0436, Mr. Burbank has been hired, I believe, by your family to represent you. He has filed motions to withdraw in all of those cases. And so do you have any opposition to me allowing him to withdraw?
No, ma'am, not at all.
So, Mr. Burbank, you are released on all of those cases. Mr. Hill, because you are in custody, I will appoint an attorney today who can begin representing you and get ready for trial in all of your cases. All right, you can go back with the bailiff. Let's see, Mr. Philip Smith on Carrington Scott. Like I said, because I got used to that yesterday, saying your first name, because we had a hearing with Bruce and Philip yesterday, so I had to.
Only way it gets more fun is if the defendant's last name's Smith also.
I know. All right, are you Carrington Scott?
Yes, ma'am. How you doing?
Good. And Mr. Burbank, will your client waive the formal reading of the indictment?
Well, Your Honor,
We're proceeding on the lesser included, Judge.
Thank you. Mr. Burbank already alerted me as well. Appreciate that. Let me get that pulled up the right way. Mr. Scott, in cause number 25 DCCR 0538, the state has elected to proceed on the lesser included offense of a state jail felony theft from a person, and that's from March 20th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
no objection to state's warrant.
It's admitted. Is there any evidence that Mr. Scott is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft from a person, Sentence you in accordance with that agreement to a term of 180 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. That shows that this was an agreement that I...
After reviewing the facts, past offenses, and victim impact, the judge sentenced the defendant to 50 years. Justice was served, but the loss reminds us of the high stakes when reckless decisions collide with substance abuse.